Hello, everybody. Welcome to another one-on-one on Talking Feds YouTube. We're here today with very good friend of the podcast, Melissa Murray. Maybe I'll get this right by memory now. Frederick and Carl I. Stokes. Frederick I. and Carl Stokes, professor of law at NYU.
Frederick I. and Grace Stokes.
And Grace Stokes. I'm so sorry, Grace. And Carl, wherever you are, and nothing personal. To talk about yesterday's landmark and marathon arguments in the affirmative action cases. Let's just start with that feature. You know, Melissa, as everyone from MSNBC knows, an expert on the court, has followed these cases closely, as have I tried to. So 5 hours, what's that about? Is the court signaling, this is a landmark of I don't remember the last case that was anywhere close. It is, of course, two consolidated cases. But what do you make of that kind of enormous expanse of argument time for the various advocates?
So one, I think you're right. The fact that these are actually two cases that were initially consolidated and then disaggregated so that Justice Jackson could take part in the North Carolina case. She, of course, recused herself from the Harvard case because she at one time had served on Harvard's Board of Overseers. Terrible name, especially given the context of what we're talking about. But she recused herself. And so they were initially consolidated and then disaggregated for argument so that she could participate in one but not the other. Also, I think it reflects, the import of the issue, the fact that the court really just took up this question only a few years ago in 2016's Fisher versus the University of Texas, Part 2, and the fact that the United States is also an intervening party of interest here. So not just the states and the universities themselves who are litigants, but also the United States government intervening. And, we had a very long period of time with Solicitor General Elizabeth Prelogger before the justices talking about the United States national interest. Those were both national security interests and, of course, interests relating to the federal government's discharge of its responsibilities for the service academies.
And we'll get back to that. I think it was very important and the sort of tip of the spear, though who knows if it will hit. Well, I think both you and I think maybe it will
let's be real,
not.
Harry.
Yeah. Nevertheless, I won't be Panglossian this time. We congregated just after, you may remember, with some of the strict scrutiny friends, just after the Dobbs opinion, and I was thinking maybe and the three of you were like, forget about it. Well, maybe it's a kind of a jaded, cynical question, but do you think there's a way in which the table is so clearly set after Dobbs to know that, they are certainly not hesitant to mow down the most, venerable precedent? Was there some sense in which we'll give you all the time in the world, so, it will at least appear as we've given the deepest possible reflection to the case? Or do you think the court was saying we need 5 hours really to sift our opinions and understand all the questions here?
Well, that's interesting. Whether, sort of the expanse of time that they allocated to this was to bolster the appearance of institutionalism, even though I think we knew after oral argument what the conclusion of their decision making is likely to be.
I mean, maybe before oral argument, right?
Oh, yeah.
Let's, which I don't think maybe we thought the same in Dobbs. Let's compare the state of precedent here with the state of precedent in Roe. So we have at least sort of three landmark opinions, spanning 25 years and then 20 years, and so something like 45 years in which this has been established. On the other hand, the major cases here have all been 5-4, with Roe's having originally been 7-2. Has it felt over all these years? I mean, this will be one of the things maybe they talk about if they pull the trigger to overrule, that it's been sort of unstable, or to the contrary, notwithstanding the narrow edge of each opinion has the affirmation, reaffirmation, etc. Would one have said 2, 3 years ago, this is really, pretty close to rock solid, or did it always seem tenuous? Would you say?
Well, I think one thing that's quite different about this relative to Roe is that the whole principle of affirmative action isn't a creation of judicial fiat. It's actually born of executive orders. So the federal government and presidential administrations first initiated the policy of affirmative action through a series of executive orders relating to federal employment and federal contracting. So this isn't a situation where there
Are
was
we
a
in post-Civil War, you mean,
this is in the
or you mean more recent?
1960s.
Huh.
This is the
Yeah.
1960s and
Yeah.
1970s where,
Well,
I
because
mean,
there's also real evidence that came out yesterday of,
exactly. Well,
certainly
I mean,
race
but what we
conscious employment.
know,
Yeah,
what we know of affirmative action, like what we
yeah.
call affirmative action, is a creature of the 1960s and 1970s, that sort of post Brown kind of moment. And it was done at the federal level through executive orders. So ostensibly with some kind of popular participation at stake. And then, of course, there's been some debate at the state level. A number of states have, through statutory and constitutional amendments to their own state constitutions and state laws, have prohibited the use of race. Most famously, as you and I know, California and the University of California system. But I don't know that there's ever been a time when affirmative action was understood to be rock solid, because even as it was initially pioneered in the 1960s and 70s, it was immediately assailed as being reverse racism, right? So that
Right.
sort of charge of reverse discrimination has always dogged it. So, in a way, it's kind of interesting. When Roe was first announced in 1973 with the 7-2 vote written by a Republican appointee, there wasn't immediate backlash to Roe. That actually was developed and cultivated. And I think what actually is quite interesting is that the abortion issue actually furnished an environment in which conservative elements could sort of bring all of their issues and grievances together. And among those issues and grievances was affirmative action. So in many ways, the debate over Roe, which really crystallized in the late 1980s, provided a sort of auger in which the distaste for and interest in dismantling affirmative action could really flourish.
Okay, and so just to finish setting the table for yesterday. So we have, many people know that you could think of several reasons to try to be race conscious in selection for universities. The court has settled on one, did in the Bakke case, and that's been the one going forward, and it's.
Well, I think we saw the limits of it yesterday.
Well, there you go. So let's start there. So the idea has been the accepted view from originating in Justice Powell and Bakke is that you can't do it for certain reasons, like you can't do it just to remedy the vestiges of slavery and the like, but there's this compelling state interest which you need because you are discriminating on the basis of race. This has always been an area of that's a kind of counterpoint to strict scrutiny, if I can use a phrase from your podcast, being strict
Well,
in
we didn't
theory,
invent it. We didn't invent
fatal
that
in
one.
fact. Oh, you didn't invent, right? No, I think I did have it in law school, and I always remember it's strict in theory, fatal in fact. But in fact, this has been a signal area in which strict scrutiny has not been fatal in fact, because again, the court has said diversity is a compelling state interest, and it's narrowly tailored to the programs of the various universities. So yeah, it comes out yesterday that after 45 years or so of this, a couple justices pronounce confusion, they're perplexed about what is diversity. So that's a pretty first principles kind of question to come out. What do you think that was about? Or does Justice Thomas in fact not understand what the court has meant by diversity all these years, or is that a kind of rhetorical broadside?
Let's roll back a minute. So, again,
Yeah.
when affirmative action was sort of pioneered in the 1960s and 1970s, it was explicitly for remedial purposes, that there were these
Yes.
institutions like federal employment, higher education, from which underrepresented minorities were clearly excluded over a period of years. And this was, again, affirmative action to remedy that past exclusion and to bring them into these aspects of society that were actually essential for social mobility. So there was initially this remedial aspect to it. And again, this is what fuels, I think, some of the distaste and backlash to affirmative action, these calls of reverse racism, where people were like, well, I didn't own slaves and I didn't do
Right.
this. I mean,
Yeah, exactly. Yeah.
well, I mean, which I'm always sort of like, it's like when I call someone like a call center about a product that hasn't worked. I'm like, you sent me this defective product.
Yeah,
I didn't
exactly.
send you that
Yeah,
defective product. I'm
exactly.
like, well,
Our
obviously,
policy, man.
I mean,
Yeah.
it's just like, it's sort of maddening. Like, of course you didn't, but we live in a system where enslavement did exist and it had these really real and pernicious effects that retarded the opportunities of certain groups to move ahead. And, that was what this was intended to make. So, I mean, I do think the remedial interest is perhaps the best and clearest and most historically grounded reason for affirmative action, but it gets really short
And
shrift.
even arguably an animating one, even as the court continues to disclaim it, right? I
Well,
mean, there was always this
yes.
sense of like, we can fasten on, we can all come to agree on a factor that, well, that's part of the argument. How important is diversity? But it's always seemed like, the big point in the room is the one that the court is saying we won't even look at.
Well, but I mean, this is where the affirmative action debate is really like the abortion debate. Like, as they switch from,
excellent. Yeah.
disclaiming remedial interests to diversity, what we see is sort of the narrowing of what is diversity, how could you achieve diversity, and this insistence that diversity is permissible, but it has to be really narrowly tailored, which really sort of, again, narrows the aperture through which race can be used in these various protocols. So, like you have to first show that you tried race neutral means, and that was not successful in actually achieving the kind of diversity that you wanted. You have this question that Justice Thomas reiterated repeatedly. What exactly is diversity? How will you know when you've achieved it? Is it having this many number of Black people, this many number of Latinos, this many women? Like, what is it?
And interestingly, he was so starchy and old school in
Well,
wanting to
I
know.
thought this was amazing. I mean, this is
Yeah,
where you really had kind of such a clear generation gap
yeah.
between the two Black justices on the court. So, for the first time in the history of the court, we have two Black people who not only reflect very different ideological perspectives, they're actually of two entirely different generations. And Justice Thomas is this sort of elder statesman who's like, in my day, I went to segregated schools and they weren't necessarily terrible. There were academic benefits to segregation. And you have Justice
And not just that. And school is to learn, young
Yeah, I
fella.
don't. We don't
And
send our kids to
what do
school
you
for
mean? How are
fun.
you? How's this helping you learn
Yeah,
about Plato? And
and
that's what school's
chemistry. Yeah.
about. Not a social institution. That's
Well,
where
I
we
mean,
all went awry in the
well,
60s.
I mean,
Yeah,
it is actually really interesting. He has this
yeah.
vision of school
I
that's
agree.
not about the whole child, but about reading, writing, and arithmetic.
Work hard, get wrapped on etc. So yeah,
I mean,
yeah,
every school is a Catholic school. Every school is a seminary,
that's really
which
true.
was so interesting. And then Justice Jackson, who is not much older than me, and I think we are in that generation,
Yeah.
that post-Brown generation that actually got the benefit of actual integration, where kids were bused to schools so that schools could be integrated and have diverse populations. That really dies off after, we leave high school as more and more people sort of move to the neighborhood school movement. Busing is invalidated by the court. But we were in that kind of sweet spot where integration really thrived between, I'd say, like 1980 and 1995. And she's part of that generation. And for her, diverse educational environments are the default. And so, she's asking these really interesting questions. And more importantly, showing that maybe the questions the majority are asking about affirmative action aren't the right ones. So there was this really devastating hypothetical that she offered Patrick Strawbridge, who is arguing the North Carolina case in favor of the Students for Fair Admissions, where she said, what if you have two prospective applicants? One who is a fifth-generation North Carolinian, whose family has attended the University of North Carolina for generations, and she wants to attend because she wants to further her family's legacy of being legacies at the University of North Carolina. That's the first
Go
student.
Tar Heels, yeah.
What about the second student, who is also a fifth-generation North Carolinian, except 2 of those generations were enslaved. And they've actually never had anyone go to the University of North Carolina because of that state's history of pernicious exclusion of individuals of color from the University of North Carolina. And she wants to attend the University of North Carolina to honor her family's legacy of helping to build the state, but never actually getting to participate in its storied institutions. And she says, like, under the plan, as Strawbridge and Students for Fair Admissions have articulated, one student, the first student, can talk about her experience, and it can be valued and credited by the school in reading applications. The second student cannot, because her experience is so closely correlated with race, according to Mr. Strawbridge, that it is essentially race conscious and cannot be counted. And Justice Jackson asked the real question, why isn't that the equal protection violation we're worried about? The viewpoint discrimination violation we're worried about. There might actually be broader 14th Amendment and First Amendment concerns here when we prohibit certain students from talking meaningfully about their experiences.
Yeah, I thought one of the things that were so devastating about that hypo is they really brought home a little bit the tension we've been talking about, remediation versus diversity, and the court's strong mindset of this has to stop sometime soon, being
Well, that was
more
only
that's
with the conservative supermajority.
well,
So
yes,
they all
and by
wanted.
the court, I mean the five,
Whereas
but
you had the 3, Kagan, Sotomayor, and Jackson, talking about we still live in a society with pernicious discrimination and indeed
yeah,
systemic
but Melissa, I'm
racism.
going stronger because even without that, there's gonna and it seems to me that they were chasing down where the majority this some mirage image of
Yes.
color blindness because in some future completely just society, it nevertheless would be the case that one's race and heritage would be among would inform personal qualities that would
Well, this was
enrich
Justice
an overall
Alito's
university
rural
environment.
African hypothetical, which
There
was
well, I
mind
don't yeah,
blowing.
right,
Can we talk about this? This
sure,
actually
go
I
for it,
felt was
yeah,
like a slight microaggression in many ways. So
yeah,
Justice Alito at one point
yeah.
in the North Carolina
He had
case.
2 points like this where he was like, "Oh, come on, what is this, 1952?" But go ahead.
Well, so I call this the rural African hypothetical. So
Yeah.
Justice Alito asked Patrick Strawbridge, or actually, I actually don't know who he was asking. I was so flummoxed by the hypothetical, but there is a student from Africa who immigrates to the United States, and his family immigrates to some rural place in the Midwest, and he wants to write about his experiences with the culture shock of coming from Africa and just being dropped in the middle of Kansas or something. And he's like, can he write about that? Can he write about like his cultural disorientation? And the lawyer is like, well, of course, because it's culture, not race. And everyone Black in the room is like, it's kind of a little
Right.
bit about race. Like part of the cultural disorientation is about not just being from a different culture in Kansas, but being an African in the middle of Kansas, where there probably aren't a lot of other Black people like you, and as Justice Alito has conceived the hypothetical. And, he was adamant, this is a cultural question. This is not a race question. And that kind of goes to the insistence on colorblindness, even if it means misreading someone else's experience.
Yeah, I mean, one sense is they haven't truly thought through what their ideal society honestly would look like and
Well, haven't
resemble. It's
they?
almost like a
Haven't they?
eugenics experiment. All right, let's
Haven't
stick
they?
with
I
it.
mean, it
Let's
feels like it's a society where,
yeah.
you know, there aren't a lot of people of color.
For starters, or somehow their color, we are all blind
We're blind
to
to
their
their
color.
color and the way.
Kagan had a great hypo here. I want to stick with the conservatives for a little bit longer, but I'll proffer Kagan's excellent hypo based on gender, where I guess the numbers suggest that if you did everything completely gender blind, you'd have a class of 65% women. Can a school not say, that's a drag? Who wants to come here? We'd like to, just for the benefit of our student body, we'd like to shoot for 50-50,
Or because a class of
Yeah.
uneducated men is bad for society.
Oh,
That's
yeah.
another
Oh,
thing she
exactly.
said.
Yeah. So is that sex discrimination? I want to get a little more nerdy on one point, which was Gorsuch. Well, Gorsuch, for one, came back repeatedly to the interesting. Actually, we'll put that aside. But the genesis, President Lowell, one president at
Yeah.
Harvard,
Well, I
obviously,
want to talk
this
about. Can we
notion
talk
of the
about it?
holistic person
Can we talk about
being
that?
to. Yeah, but let me. Well,
Okay.
yes, let's talk about it. But
Okay.
then I want to get back to another Gorsuch point. Shoot.
So I have nothing more to say about Justice Gorsuch's insistence on talking about what he calls the origins of the Harvard Plan,
Yeah.
which he says
Yeah.
originates with Henry Cabot Lowell, who in the 1920s created this plan for the purpose of excluding Jewish students. And I thought this was really important because this is something that Justice Gorsuch does repeatedly. He did it in Ramos. This was the case about non-unanimous jury verdicts, where he linked the interest in non-unanimous jury verdicts to Louisiana's history of white supremacy and trying to sort of
Yeah.
box Black people
Yeah.
out of the jury and of having political power on juries. He's creating a new origin story for affirmative action where it is rooted in this discrimination against Jewish students. And the idea is that those racist roots, it just completely and irrevocably taint the policy going forward. So, I mean, they did this with Dobbs a little bit too in the
Yes.
whole
We're,
discussion of
yeah.
eugenics. Like, it's like the origin story for abortion is not 1973 and Roe, but 1923 and the eugenics movement. So, this is something they do a lot. They really use the question of
It's
race
a
and racial
rhetorical
justice.
jujitsu,
Yeah,
right?
it's,
We
yeah.
are the true,
We are
you
the woke
know,
warriors here.
exactly,
Yeah.
exactly. All right. Doctrinally, Gorsuch did something that I thought I hadn't heard before, well, of all things, because let me just take an aside and say, not, the questions, very few were surprising. And even I thought it was a kind of impoverished oral argument in the sense that many of them weren't even for each other. They were almost for the public. Some of these, I on both sides were really points that you can't imagine the other side was listening to because they've just been trotted out. But Gorsuch did something. He said, "Look, okay, it's strict scrutiny. Strict scrutiny means you have a compelling state interest. Let's say that's diversity, but it also means there's no alternative to do it." And I think he thought very clever. He was going to the heart of Harvard in particular. Why then isn't it required that Harvard, before going to the toxic and socially divisive step of race conscious remedies, get rid of all its legacies and do these other things that the plaintiffs have developed in the lawsuit that would completely transform that, but at least wouldn't be race conscious. So I guess my question to you is, do you expect the opinion to actually be saying, they need, we heard that word egregiously wrong. They're going to have to do that kind of,
Hmm.
this is so terrible,
Hmm.
in order to overrule. Do you see the court basically saying it's always been a mistake and an error in its application of strict scrutiny?
So I do think that they're going to have no trouble finding a way to overrule this as egregiously wrong. And I think
Yeah.
the reflexive and insistence invocation of Brown versus Board of Education as
Oh my.
compelling a colorblind
Yeah. Yeah.
response is the tell here. And we're going to see Brown literally used for all kinds of things in
Including
this
the first
opinion.
brief of the U.S. Strawbridge, I thought was,
Yeah. Yeah.
yeah,
That,
he was effective. Yeah.
um, not always effective, but
Well,
effective
you know what
enough.
I mean. He had
he
the
he was
right
arguing downhill.
temperament.
He was arguing downhill, and
Yeah,
he
that's
did it
right.
fine.
Yeah. Yeah.
Um, yeah, will they actually get rid of legacy admissions? I don't think they can because they're
Yeah.
actually race neutral on their face. I mean, I think they can sort of make noise about how pernicious this is, how this also leads to other kinds of
And there are
inequalities.
other things you could do.
Right. I'm
Yeah.
sure we'll hear a lot about that. But I mean, I think it's just really interesting. He sort of weighed in on the art museum and the prospect of the scion of a very wealthy family that could provide Harvard with donations or whatnot. But they really focused on this question of sort of specialized sports that typically aren't available at high
Yeah.
schools where students of color might attend, but are at high schools where perhaps white students would attend. And then this question of legacy admissions, which historically has credited white students, although not exclusively anymore, because we are in this first generation
Yeah.
post integration
The
where
Joshua generation or
yes,
whatever. Yeah.
I mean,
Yeah.
this is the generation of people of color who actually are in a position to transmit legacy status to their children.
Mhm.
So, in a way, getting rid of legacies or at least signaling disapproval of legacies at this point might actually make it harder to integrate some of these schools because there are people of color who could take advantage of it. I think it's really interesting that they've sort of narrowed in on that,
Yeah. Well, the
especially
whole
since
big
these
plan
are
that, you get the oboe player and everyone still did, though, make it worse for African Americans. Let me ask you one more thing before moving to Kagan and Sotomayor, and we've talked about Jackson. Seth Waxman, a really excellent advocate, I thought, and over the 5 hours, to me, there was a noticeable like rise in energy and focus when he took to the
well, they
podium.
greeted him like a prodigal son.
Right. Well, when pressed, he said, "Yes, it must be the case logically that there's going to be, 1, 2, 6 people who are admitted because of race." He was pushed to that, and they seemed satisfied, just like there were some, because of the oboe player. Was that a mistake, you think?
Well, I think it was a mistake because we just don't know that. And he doesn't
Yeah.
know that. And the record doesn't reflect that. I actually thought Elizabeth
And it's a big,
Prelogar,
I mean, you're going to
it's a
see
big
it attacking
concession.
him,
It's a massive
but
concession.
yeah.
And you don't know. I mean, like I've
Well,
done
you
it.
don't know for any given. The argument would be yes, you don't know for any given person, but okay,
Well, I mean, this was
you
Ketanji
sit.
Brown. I thought it was
Yeah,
really interesting. He argued this during the Harvard case where Justice Jackson was not present
yeah,
because she'd recused herself. Because I
right.
think if she'd been there, she'd have been like,
Mhm.
how do you know that? Tell
Yeah,
me how, because this is an admissions criteria that has like 40 different factors. How do
right.
you know that race is actually determinative? And that was my question. Like, I've done admissions. Like, I did admissions when I was on the faculty at Berkeley, like one of the faculty committee members. You
And
were looking at
interim dean, might I add? But
well,
go
I
ahead.
didn't read it. I didn't
Yeah,
read files
when
when I
you
was
did, yeah,
dean, but
yeah,
you read thousands of files and
yeah,
materials on these students, and you're thinking about their work experience, their family circumstances, whether someone comes from a single family home or not, whether whether they have a parent who attended the law school, stuff like that. I mean, it's just like so many different factors. Like, how could you determine that race is the tipping point? That's like, yep, we got to have that person. That was
that's
never a
right.
part of
So
our
I mean,
calculus.
this is the notion you for any given one, and yet I think statisticians would say if it does any work there, it has to in the abstract. So that's the question.
Well, I mean,
Look,
to be clear,
Waxman
we
thought about
actually,
this very, very carefully in advance
well,
and felt he could incredibly say
Well, I would
never.
actually love
But
to know
yeah,
why. I mean, like, and to be
yeah,
fair, when I was doing this at California under 209, we actually cannot consider race. So, I
right,
mean, we were
right.
sort of, I mean, and again, I think this is a really fact specific kind of inquiry based on this school and its admissions protocols. But the Harvard protocol is as multivarious as anything we used at Berkeley. And
Yeah.
there's no one
I mean, it was
criteria that was
written by lawyers
dispositive.
to comply with
Yes.
their opinion.
Yes.
Let's be clear. When I was at Berkeley and in the law review and helping choose students, we had a big memo from Gibson, Dunn, and Crutcher, tracking Bakke and saying, here's what you can do and what you can't. Yes, they were, people have done their best to faithfully follow. There's no argument here that somehow society or universities have
I
gone
thought it
down
was a
fun of
mistake.
or
I thought it was a
ignored.
mistake to concede
Yeah,
that. I
yeah,
actually don't know why he would, and I would love to know how he knows that.
yeah. Well, all right. So fair enough. And because if it is a mistake, it's definitely going to
Well,
come
we're going to
back
hear about
to
it.
bite.
It's going to be
Yeah.
there.
I mean, there were so many things having lived through Dobbs. It was like, shit, we're gonna hear. Yeah, we're gonna hear about that. We're gonna hear about that. All right, switching sides. I thought you've mentioned Jackson's really strong hypo. I thought that in general, what all three of them did, the progressives did effectively, and especially Kagan, was to bring home how the issue here is. I mean, undergraduate admissions, that's already a pretty big point. People can understand that. But in fact, she, with the United States, made it clear like, this isn't just about universities. This is about society. This is about the ability of the military to be effective. You could see that really rankled Alito, because how are you going to, question that? This is about, and that's why you have all these amici briefs saying, keep it up. We need the pipeline of leaders who have been educated in environments that will permit them to lead workforces and others that look like America. So she was trying very hard, and I think effectively. I don't know if it will matter socially, because that really is what we're talking about now, to broaden the question into something much more, holistic, to use a word, or anchored in what all of society looks like, not just undergraduate institutions.
So let me make 2 points about this. I do
Yeah,
think that they were sort of grounded, like, what is this going to look like on the ground? And I
yeah.
think more importantly, they were trying to stanch the bleeding. Like, they know that there's a majority of 5 to overrule Grutter and to dismantle affirmative action as we know it. And so a lot of the
Let me
work
interrupt you there. You don't think they know there's six?
yeah, well, there's at least 5. Maybe Brett
Yeah.
Kavanaugh is a wild card, and I think they were very much playing to him.
Oh,
Like,
interestingly. Okay, go ahead.
I think
Yeah.
this is why
Yeah, I see
Kagan
that.
mentioned a couple of times the whole prospect of gender. I mean, he's the one
Yeah.
who's talked about, and he is the
His clerks
judge
and
who's
yeah.
talked about the interest of diversity that he's pursued in selecting clerks.
Yeah.
So I think people were trying to, get Brett Kavanaugh, or at least get Brett Kavanaugh to moderate what this
To have a
majority
concurrent
will do.
opinion, yeah.
Um, so, I think they were trying to stanch the bleeding. Like, they're obviously going to dismantle this. There have to be some windows open to deal with this because this is still a societal problem. I think the exchange between Kagan and Solicitor General Prelogger was really telling, where Prelogger essentially said, diversity isn't the only compelling governmental interest here. Also at issue is national security, which has been found to be a governmental interest, a compelling governmental
Yeah.
interest in Korematsu, not surprisingly. And so she was saying, we can't run the military without a fighting force that looks like America. We can't have an officer corps that doesn't look like America. So there isn't just the whole question of like what colleges and universities our pipeline looks like. There's actually a very real question of what do we look like as a fighting force, as an officer corps. And so, and the Chief Justice seemed to sort of latch on to this too. So, I could imagine a decision where the military and the service academies might perhaps be carved out here, or I think Justice Alito really was trying to step in to stave this off by talking about ROTC programs at various campuses. But again, this was about stanching the bleeding. This isn't about a victory. They know there's no victory in
By
sight for
stanching the
them.
bleeding, you mean having the narrowest possible
The
rationale for
narrowest
overruling?
pocket. Yeah, they
Yeah.
are trying to write this as narrowly as
Yeah.
possible. They're trying to get Justice Kavanaugh on board. I think this is why Prelogger had that, sort of weird, not weird, but like a little snarky kind of subtweety moment where she was like, FYI, fellas, we are at rough gender parity in law schools, and yet I'm one of 2 women arguing before you in this sitting. How can that be? How can we be in a colorblind, genderblind society if that happens? And that, I think, was aimed right to Kavanaugh, who has professed to care about such things.
Yeah.
Um,
But I think it's a very effective strategy. If and now, of course, I think the court isn't really up for grabs here. But if they were, I mean, first there's this is what rankled Alito. Oh, now you're pulling that national security card. We're not allowed to question that. Rats. But it more broadly than that, the military is the institution
yeah,
held up by many conservatives as the ideal of what the society should be going for. And
yeah.
here the service academies are bringing home, yeah, you love us here, right? Guess how we get to be effective this way.
Well,
We get to,
also
I mean,
the first
imagine what you
institution in
may
American
actually be
society
imposing.
that was integrated.
Right. Right. And you may be imposing on us a state of affairs where our pipeline for leaders is hugely, lacking
Depleted.
in
Yeah.
representation, and they have to go into the field and make life and death decisions where some of the service members are going to be looking up at them and thinking, I'm not going to follow you. I mean, this really does seem a compelling interest. And yet the third point I want to make about it is it's life and death, but otherwise it's strictly parallel to what's happening in business
Hmm.
and other institutions,
And
if
Prelager talked about that, law firm. I mean, and Kagan reiterated it. It's not just the service and the military, it's
it's
law
the precise
firms.
same
It's,
thing.
yeah.
If a law firm fails, we don't get taken over as a country, but it's the exact same. If they want to succeed, they need, and it does seem like quite a intrusion by the court to be. It changed around the terms of the debate, at
Yeah.
least yesterday. We'll see if this abides and when people think about it. From what schools look like, especially elite schools, how much does America really care about that? A little, to the
Oh, I think
effectiveness
people
of
care about it a
institutions.
lot. Oh, I think people.
Well, okay. I just mean it's discreet.
No, it is
And
discreet.
yeah,
I think that's right.
yeah.
But I do think, in terms of like sort of a conservative talking point, it was really smart to sort of talk about the military and how the military could be compromised by
Oh, I no,
dismantling. Yeah.
absolutely. No, I'm saying how much do people themselves care what UNC or Harvard looks like is what I'm saying. And this switched it around to say, yeah, but we're talking about it's the minor leagues to the country,
Well, I mean, I
and
think that's right.
yeah,
I just want to sort of like, I'll push back and say, I do
yeah.
think people, even if they are not attending UNC or Harvard, I think they do care what higher education looks like
Yeah.
in no
But
small.
to elite institutions, I guess is what
Well,
I'm
but I
thinking.
mean, I think most people in this country understand that social mobility is really tied to access to these elite
Yeah.
institutions. So, for those
And
who
the American
disfavor,
dream. Yeah.
yeah, for those who disfavor affirmative action, it is because it means foreclosing opportunities to the American dream to some people. And they think it's done on a race basis, when in fact, the chance of your kid going to Harvard is pretty minimal in like, given the numbers of applicants and how selective that Harvard can
Yeah.
be. Um, but that is the view. Like, if my kid doesn't get into Harvard and it's because some other less deserving kid has gotten in, we've been foreclosed from the American dream. And I think other people see it the other way, again, because they favor affirmative action. That is our chance, like, out of, generations of poverty, generations of exclusion, and, a chance for social mobility. And I'll be very honest. I went to the University of Virginia, and I went from a Florida high school that no one had ever heard of. It was good, but
Yeah.
it wasn't great. I was a really studious kid. I put my head down and worked. My parents didn't have money for fancy prep courses. I got a really good verbal score, probably a respectable math score, but not a perfect score. And I got in and I got a full ride, and it totally changed my life. Was I a
Yeah.
beneficiary of affirmative action? Probably. I'm sure, like, there were a lot of things that were great about my
Well,
application.
as you say with Waxman, it's very hard to say.
Well,
But this was a meta critique also on the right, with Alito's point of it's just like Thomas education. Alito was in the same kind of crimped way. It's a zero sum
but
game.
it's
So
not.
that
There's
means
plenty of stuff for everybody. That's the thing.
right.
Your kid won't go to Harvard. Maybe you'll go to Amherst. Like, you'll be okay. It's going to
Well,
be fine.
this is the broader point, and I've just, I'm living it myself as a parent of teenagers. All right, just a minute or two. You've got to go educate our still diverse possible student body. But let me ask you: do you see any possibility that the court um, has separates in any way in its rationale for Harvard, which is not bound by the Equal Protection Clause, but by federal civil rights laws, since it gets hundreds of $1,000,000, and UNC, which is a
Yeah.
straight Equal Protection Clause analysis?
I mean, they're two different cases with two different logics to them, one constitutional, one statutory. I do think Harvard's going to lose, and I think it's going to lose big.
You
Um,
say it again,
I
please.
think Harvard is going to lose. I think it's going to lose big. And what's actually really important to recognize about that, like, Harvard's not going to lose on the constitutional question. It's going to lose on the statutory question. But that statute, Title VI of the Civil Rights Act, affects not just Harvard, every private institution, as well as employers that receive federal funding or receive federal contracts. So a loss for
Now, and by the
Harvard.
way, maybe Title VII and Title IX,
Well, I mean,
also.
there are
Yeah,
going to be
right.
reverberations
Yeah.
well beyond Harvard. That actually may be more pernicious than the constitutional loss that I imagine UNC is going to rack up on this. Yeah, I do actually think we're going to see just a complete transformation of the employment and the educational landscape because of this. And I think there are going to be questions that the court did not take up today that were sort of hinted at, like, but what happens post admissions? Can you have a scholarship that is for the descendants of slaves? According to Mr. Strawbridge, you cannot, because that's too closely correlated with race. Like, well, of course it's closely correlated with race. Enslavement is about race, about the subjugation of a particular racial group. But apparently, you can't do that. So, we're going to have a ton of litigation about these other institutions, employers who receive federal funds, employers who are government contractors. We're going to have a ton of litigation about post admissions operations, like what universities, colleges, employers can do once they make a decision about who is in their group.
It is this year's wrecking ball from the YOLO court. Melissa Murray, the Frederick I, and Grace Stokes, professor of law. Always a pleasure, and to get your thoughts. And I feel a lot illuminated on this. What are we gonna say? This
You
huge,
only
probably the
live
case of the
once.
term. Yeah,
Eat the marshmallow. The court is eating
yeah.
its marshmallows.
All right. Thank you. Talk to you soon,
Okay.
I hope.
Thank you.
Bye bye.
Bye.